Hello everyone, thank you for joining us for this data privacy seminar today, where we get to hear insights from our presenters, who are all lawyers from different US Laboris firms across Europe. My name is Annie and I'll be the facilitator for today's session. That is it from me. I will now hand over to our host, Alexander Milner-Smith. Go ahead, Alex, you can start.
Thanks very much, Annie, and hello to everyone. Thanks for joining us. My name is Alex Milner-Smith. I'm co-head of the data and privacy practice at US Laboris member Lewis Silkin. I was a labour lawyer for about 5 years until around 7 years ago. Data got the better of me and I pivoted into doing more and more data. So I still have a small employment practice, but primarily work in marketplace and workplace data all around the world. It would be remiss of me not to mention Schrems. I appreciate we are going to have a session on subject access now, but of course this morning the Court of Justice of the European Union, in its infinite wisdom, we aren't going to mention it today, but if people want to ask questions about that in the Q&A, we can of course try to handle a few questions. I would suggest that 10 minutes for your Q&A for Schrems is not going to be enough, but I'm sure we'll do another session around that in the near future. Today is all about subject access requests, and if you don't know what a subject access request is, don't worry, I'm going to go through that in a second. But we've sort of framed this as a speed dating session, and probably shows that I've never been speed dating, because I don't think it will be anything like speed dating. But the idea is that I wanted to show, and we, the Alliance, wanted to show the similarities across continental Europe and the UK in relation to subject access requests, but also some of the differences between jurisdictions and how we approach it from a legal perspective and a practical perspective. So you'll see on the slide here all the different speakers that we're going to have today. We're going to have some people from Ireland, Italy, Holland, Denmark, Germany, Belgium, and Sean is also going to give a UK perspective along with me. And we're going to have sort of three sections. We're going to have three formal sections, as it were. I'm going to take people through what is a SAR and why people bring them in very much summary detail. And then we're going to stop and have a speed dating session where we go around Germany, Holland, and so on, just running through a few of the nuances in terms of those countries. Then we're going to have a more formal session on what we see in the UK as the tactical approach to SARs and what you can do practically to respond to them. We're then going to go on and have another session, speed dating, just around the various countries. And then I'll finish with a little bit of UK case law, because the UK is, for want of a better word, quite mature in terms of its SAR case law. There have been some very significant Court of Appeal decisions, which is the second highest court in the land in the UK. And they are quite relevant for potentially how things might develop across Europe. But then we'll finish again with a speed dating session just on what are the key case law decisions that there have been in the various countries, or what are the key regulatory guidance in each country. So I hope you'll get a flavour of at least what a SAR is. I hope you'll come out of this session understanding what a subject access request is at the very least. But more than that, understanding the nuances across your potential territory of your spheres of influence and how you might approach an international SAR and so on. So first point, what is a subject access request? Now it's writ large here in Article 15, and you will forgive me for looking left and right. I'm not an anxious speaker, it's just I have so many short screens, and I was so proud of them initially. It now makes it very difficult for me to see where everything is on my system. But Article 15 of the GDPR is very clear. The data subject shall have the right to obtain from the controller confirmation as to whether or not personal data concerning him or her are being processed, and where that is the case, access to the personal data. So two key things there. One, it's access to personal data that someone is processing about a data subject, and two, it's only relevant to a data controller. We don't have time to go into what is a controller or a processor here, but as this is very much a workplace-based session, most of us on the call will inevitably be controllers of the personal data of our data subjects that we process. So when we receive SARs, we can't do the wonderful thing that processors can do, which is just bat that back to a controller and say, you deal with it. When you as an employee file a SAR against your employer, or you as a freelancer file a SAR against your engager, inevitably the engager or employer will be a data controller and will have to answer it. Now, there are lots of other data rights. The right of rectification, i.e. correction, the right of erasure, deletion, right to be forgotten, the right of restriction in certain circumstances, and the right of data portability. Lots of the tactics we're talking about today do apply in inequality to those data rights, but today we're focusing only on subject access request. I will give a horror story that we do have in the UK. It's the 5R email, which is the 5 request email, where you will receive from a data subject, maybe an ex-employee, a data subject access request, followed at the same time by an erasure request, at the same time a request for restriction of processing while you deal with their disciplinary, and then maybe a request to port their personnel file. So you have that, and potentially also a request to correct an inaccurate piece of data from 2001. And the whole purpose is to cause problems for your organization, but we'll talk to that in a second. I hope there aren't too many of those knocking around Europe, but we'll hear about that later on. Just a few key points before we move on to the first speed dating session. Timeframes. Previously, you had 40 days to respond to a SAR. You now have 1 month to respond. That is the default position. Save when a SAR is complex or potentially numerous, you potentially can extend that by a further 2 months to produce a 3-month period for responding. Now, each SAR needs to be looked at in isolation on a case-by-case basis. But we tend to see that our marketplace SARs are very much easier to respond to. They take 1 or 2 weeks. It can be very heavily automatized. But with our workplace SARs, we do find there is complexity. There might be a court case running. There might be more third-party data. There might be more media through which we need to look. And as a result, we do tend, although we don't always, we do tend to extend time to 3 months. Obviously, tactically as well, there can be occasions where you need to extend time because settlement is only just around the corner and you don't wish to waste hours and hours and hours dealing with a subject access request when you could, of course, settle and someone could withdraw the subject access request. In the old days, you could potentially charge a fee. You are not supposed to charge a fee now, save in very rare occasions. And some of our clients get very excited by fees and they say, we're going to charge 25,000 euros for someone to, in order to answer a SAR. And we say, look, maybe this is a rare occasion where you can charge a fee. The regulator in the UK, the ICO, suggests a fee of £500 would be adequate. So, of course, you get into this issue that if you do charge £500 and they pay it, you then have to respond in full. So we tend not to recommend charging a fee or even attempting to go down that route. Article 12 does still apply to SARs. It's where the rules around complexity come, but also the Article 12 clause is all about transparency. So in any communication you have with a data subject, be it initial correspondence or when you're actually providing the data, you do have to respect those transparency modalities and you have to be concise, transparent, intelligible, and everything has to be provided in an easily accessible form. Because after all, subject access is a fundamental right of the EU Charter of Rights. So it's almost akin to a human right. So you can see the regulators and indeed the European Commission are very keen for controllers to take subject access very seriously. Now I'll quickly run through Article 15 in 10 seconds because you can read it yourselves, but this is the other information you need to provide, along with providing copy data, although I'm sure probably Soren and maybe Jessica are going to touch on whether you provide copy data or not. There is still an open question there, but along with providing copies of the data, you then have to provide lots of other stuff. What is the purpose of the processing? What's the categories of personal data? Who are the recipients? What are the sources? Do we send data around the world? Do we ever So SARs are a massive window into your compliance file. It is not just about providing people with their personnel file and 2 or 3 other documents. You have to provide this extra documentation that allows a data subject to check your compliance profile in general. Is your privacy notice correct? Do you have good retention periods? Do you have model clauses, or are you utilizing Privacy Shield when you send data to the United States? And so on. And it allows them potentially to make quite a sophisticated complaint to a regulator. It's certainly the way we're seeing them in the UK. And that brings me on to my last point before I move on to the speed dating. Actually, last 2 points, forgive me. First question that we always get asked in the UK is, do I have to provide everything? Oh my goodness, this employer's been with us for 10 years. There are 1 million data sets that are potentially responsive to their SAR. And the answer is, of course you don't. And there are varying graduations of why you don't have to do that. But starting first with proportionality. The whole aegis of EU law, and indeed UK law in some parts, has proportionality at its core. You don't have to broadly do something that is disproportionate. And that is actually writ large in the recital that accompanies Article 15, recital 63. it clearly says that where the controller processes a large quantity of information concerning the data subject, the controller should be able to request that before the information is delivered, the data subject specify the information or processing activities in which they're interested. So you are allowed in some ways to reduce the scope of a SAR, because you can recognize that I want all my data from a person who has been with you for 10 years and just been sacked for whatever reason is an enormous, nay, impossible task to do. Secondarily, recital 63 also talks about that the right should not adversely impact the rights of others, and also suggests that you don't have to provide confidential business information either. So that allows you, it gives you an idea that you don't have to potentially provide third-party data. You need to be careful with your own confidential information and so on. And just as an example, in the UK, we don't just rely on recital 63, we've actually put in our legislation various exemptions. So privilege, legal advice or litigation privilege. If something is covered by privilege, you do not have to provide it. Third-party data, we have quite a sophisticated balancing exercise where you have to balance the rights of the requester and rights of third parties. And sometimes that means the balance comes in favour of the third parties and you don't provide certain data sets because they have third-party data in. We also have things like confidential references and negotiating mandates and so on that might not need to be provided. And a lot of these things are reflected around Europe as well. So key point is, yes, data subject thinks they're entitled to all their data. They technically are not, because that's an absolutely important point to understand. And finally, before we just move on to the first speed dating section, why are SARs used? Now, one time in a billion, a worker genuinely wants to know how their data is processed for pure reasons, because they're extremely interested in data and privacy, and they're the next Max Schrems, and they want to be a privacy activist or something like that. Most of the time, SARs are used tactically. They can help a data subject gain leverage in settlement. You can be offering someone €250,000 million euros, and if someone files a SAR, however, and they have a lawyer on the other side, we have seen with some of our clients in the UK, they recognise it's worth adding £100,000 onto that just to get rid of the SAR. I'm sorry to say, it just is sadly a litigation tactic. Also, actual and potential litigants often use it as what we say in the UK as a pre-litigation fishing exercise. Litigation and disclosure can take months and months and months and months, whereas theoretically, a data subject can get access to some data within 30 days, and that can potentially help them with their claim and so on. Further, there is this, sadly, a second layer of leverage. They can make threats to go to a regulator. They can make threats to bring a private right of action under Article 82. And I will say, shamefacedly, I very rarely act for individuals, once every 5 years, but I was on the verge of bringing a very, very big case under Article 82 last year for a very very wealthy individual. We were doing it to cause problems. We all recognise that. There were genuine data concerns, don't get me wrong, otherwise I wouldn't do it. But my motives and the client's motives potentially were somewhat different. His motives were not necessarily the purity of the law. So it is very important to understand the motive of a data subject. But you've got to recognise it is not a reason for refusing to deal with a SAR. I have been on a panel with the Deputy Irish Data Protection Commissioner 2 or 3 years ago, and he said, we recognise that most SARs are brought for other motives. However, we must be motive blind, and we will deal with complaints as they come in. So that's very important for data controllers to understand, that you have to be motive blind, certainly from a UK and Irish perspective. Now, that leads me on to the very first speed dating section, and my colleague Jessica, who I know very well from Germany, has the pleasure of starting. And Jessica, are SARs and are specifically workplace SARs common in your country, and do you see this changing? And also do introduce yourself as well.
Yeah, my name is Jessica. I practice as an employment lawyer in Berlin. I've been interested in data privacy for more than a decade. It started with the implementation of an ethics guideline more than 10 years ago. And SARs have been increasingly common in Germany since the implementation of the GDPR. Before that, there were some limited rights under different statutes of German law, but we see that they are increasingly common. They are, as you just said, Alex, they are really getting part of the day-to-day strategy on the plaintiff side, as you just said, it can be aiming for a golden handshake or part of a discovery, a fishing expedition.
Thanks very much, Jessica. And it is interesting because we do feel in the UK, and I think in Ireland as well, which Linda, I'm going to come on to next, that we have been sadly at the forefront of people using SARs. But I think it does sound, Jessica, that in Germany you are beginning to unfortunately get the bug, and some of your employers are beginning to understand how annoying SARs can be. But Linda, in Ireland, what is the position there?
Yeah, hi. So my name's Linda Hines, and I'm a partner in Lewis Silkin Ireland. And unfortunately, SARs have been a huge feature of our employment law landscape for many, many years pre-GDPR. Because our tribunal system is quite informal, there's no discovery, there's no real exchange of documents in advance. So an employee will nearly always bring a subject access request when they have a dispute with their employer. And as you say, it's very similar to the UK. They're nearly always used to leverage severance agreements or settlement agreements because there's a real nuisance value to having to deal with them. So that's the position in Ireland.
Thanks very much, Linda. And I'll go on to Soren next. Soren actually spent 2 years at Lewis Silkin and sadly learnt all about SARs. And I think he's taken it back to Denmark and is perhaps encouraging the knowledge of SARs. So Soren, what's the position in Denmark?
Yeah, that's the whole purpose of me being here. So I think historically, even in the last 2 years since GDPR entered into force, SARs has not really been used strategically or tactically in Denmark. Mostly we've seen SARs relating to, or in SARs, particular documents have been requested. But you don't really see those wide, broad SARs, give me any and all the data you have about me. But I would say in the last 6 months, we see more and more of those, particularly in the dismissal context. So it is certainly something that data controllers are becoming more and more interested in and should become more interested in because there's something on the way.
Thanks very much. And rather embarrassingly, I'm going to turn to Sean in the UK now to give a little bit more colour from the UK.
Yeah, hello everybody. So I'm a senior associate in the employment and data teams working very closely with Alex. I mean, as Alex has said, SARs are very common in this country. They are part of the trilogy of tactics that employees will bring. There's the tribunal claim, the grievance, and then the DSAR tends to come along with it. As Alex has said, SARs are very, very common in the UK, and actually I can only see them getting more common as the current landscape means that redundancies are going to be happening. There's just more incentives for people to be bringing SARs at the moment.
Yeah, I do think we do see, sadly, a COVID-19 windfall in SARs. We do think that as more redundancies are made from when our furlough scheme is perhaps unwound in October, as Sean mentioned, the trilogy, there will be definitely a massive influx of SARs. And Marco, in Italy, what's the position there?
Thanks, Alex, and good afternoon, everybody. I'm Marco Sideri. I'm a partner at the Italian Ius Laboris firm, Toffoletto De Luca Tamayo, and SARs are common in Italy as ancillary moves in a wider litigation scenario. That's something that's been mentioned. Another interesting point is there a new language for HR people and sometimes also for employment lawyers. So in Italy, they're just starting. Maybe it's fishing, discovery rules are different here, but they do come from other sources. They do use other legal reasoning. So sometimes they slip through the cracks of HR offices, or they do provide different arguments to litigation, which may take employers by surprise. So we're learning to know them and to putting them in their place in the more in the wider employment litigation scenario, and that's about it in Italy. Thanks, Alex.
Thanks very much, Marco. Yeah, we are focusing today on the workplace, but we obviously see a lot of marketplace ones, and I will perfectly happy to admit on Lewis Silkin's behalf, we actually receive them occasionally from our clients, and we're delighted to deal with them. Of course, we welcome that, but we do also receive them bizarrely from opponent solicitors and indeed opponents of our clients. And this is the new thing. Now, we in the UK have lots of ways to deal with that, but it's just something that is in everyone's arsenal. And if any individual claimant lawyer would be negligent if they did not advise their individual client about a SAR. So, Elsa, in Holland, what's the position there?
Alex. Well, my name is Ilse Bijens. I'm an associate working at Bronsgeest Deuradvocaten in Amsterdam, and I'm part of the privacy team there. To be honest, Alex, I must confess that workplace SARs are not that common in the Netherlands. Since last year, however, we do see more often that employees involved in dismissals cases, and then in particular in non-performance cases, ask for a copy of their personal file, but mostly still if a lawyer is involved in the case. And access requests by employees themselves are still quite rare in the Netherlands. That's the position for the Netherlands for now.
Thanks very much. There is an element of Eurovision to this, which I'm quite enjoying, which I know Sean will be enjoying as well. And finally, I think we've got Wouter in Belgium. Who's on mute? I think he might still be on mute. There we go.
Okay, so my name is Wouter van Loon. I'm working at Kleijs in Belgium. I'm also specialized in privacy. And just like the Netherlands, Belgium does not really have like a tradition of providing access or disclosing information. Therefore, SARs are less much common than they are in the UK. However, in our daily practice the last year, we see more and more that lawyers, trade unions, but also employees start submitting more and more SARs, mostly in view of potential legal proceedings or simply to annoy the employee in case of a departure or a dismissal, for instance. So that's the position or the status in Belgium.
Thanks very much for that. And actually, Wouter, you raise a good point there about trade unions. We do sometimes see SARs filed by trade unions on behalf of their members, and we are waiting for the next stage in that, which will be the mass SAR, where a union files one on behalf of 10,000 people, and we're going to have to work out how to deal with that. We are waiting for that, not necessarily with bated breath, but we do think it's going to happen because we can see there a potential linkage to data breach claims as well, mass data breach claims, and class actions and group representative actions as well, which is obviously a big talking point in the UK. So just moving on to the next formal bit, which will be around 4 minutes, Annie, because I know I'm very conscious of time. Just controller tactics. Now, this is from a UK perspective, but you know, Article 15 is Article 15 in the UK, in Belgium, in Holland. It doesn't really matter. And most of these tactics should be recognisable across Europe. And indeed, when we've worked on SARs cross-border, many people, many of our European colleagues do recognise these tactics. The first absolutely key point is, who is your audience? Okay, your audience is not the data subject. I don't care about the data subject, if I'm honest with you. Our audience is ultimately the regulator, and in the UK, a court, if you ever are potentially up in front of them. Because a data subject, certainly in the UK, is always going to be apoplectic with rage with whatever response you do. You can never satisfy them. You've always missed a document. You've never provided them enough. The search terms that you utilize are never acceptable. You are behaving in an appalling manner, okay? That is always how they are thinking of you, bearing in mind the tactical considerations we discussed before. So when you are writing to them, you are writing to them thinking every time, in my opinion, you should be anyway, this might be in front of a regulator, the ICO, the Garante, the CNIL, the Hessian regulator in Germany, whatever. They are potentially going to read this letter, and every letter I want them to be able to read easily to see that, 1, I'm a good data protection citizen, 2, I care about the fundamental rights of subject access, and 3, I love data. I absolutely love it. I really am the most compliant person ever. Okay, so I know it sounds silly and it sounds noddy, but that is the game you have to play with regulators. And so this even starts from the very first moment you receive a SAR, because the way that you acknowledge a SAR will potentially set the tone. Are you going to be suggesting it's complex? Are you going to have to be saying to someone, hang on a second, you haven't provided your identification, therefore we need a delay until your ID is with us. Hang on a second, you've asked for all data, but we don't even know anything about you. You left 15 years ago. So everything, you need to think, who is our audience? And from the early stages, any decision you make, you really need to be in a transparent manner, setting out your reasoning. So that is from the first point of call. Why isn't the ID good enough? From the second point, are we going to extend time? To a third point, my goodness, you're wanting 18 million documents. Well, we can't do that, it's disproportionate, but we're going to put in place these search terms to look at 3,000 documents. You need to be transparent, because later, and Sean and I, and indeed Soren, been involved as well, and Linda in Ireland as well, we've been involved in many tens, possibly hundreds of ICO actions in relation to SARs. And I've been involved in a few in Italy, Belgium, and Spain as well, and France actually. And when people have written good letters and have a good narrative, a compliance narrative, it helps them. And you know, I know this is a silly thing to say, but be reasonable, polite, and proportionate at all times. The number of clients we still have in the UK who still say to us, this person's doing this to just get some more money. Can't we just tell them to go away? Perhaps less polite terms than that. No, if you do that, you are then going to have a problem with a regulator. Bearing in mind it's a fundamental right, that is the last thing that a regulator wants to see. So trite as it is to say, fail to prepare to fail, obviously. Responding to a SAR necessitates really a multidisciplinary approach, okay? So it is not just something for an HR team to deal with, okay, unless it's the personnel file, but you're going to have to get IT in. How do we search all our systems? You're going to have to talk to legal, because maybe there are litigation holds that need to be put in place. Maybe you need to understand what the litigation makeup is. Maybe you need to understand how your organization views in-house privilege and so on. And obviously HR teams themselves are going to be absolutely crucial. So you need to set that up. And in some ways, when we are doing data audits for our clients, as part and parcel of setting up accountability within the subject rights request space, we do suggest having subject rights requests and subject access request protocols, setting up what happens when a SAR comes in, potentially having macro documents and template documents you potentially use initially to triage a SAR and so on. It helps you look good from an accountability perspective, but it also means that you're not reinventing the wheel every single time that you respond to a SAR. Then let's understand the background to a SAR. I said motives are irrelevant, but Sean and I and Soren and Linda have received many SARs where actually 2 weeks later a deal is done, the settlement happens. So the last thing you really want to do, and your clients will not thank you for sending them a £25,000 bill after 2 weeks when suddenly the case is settled, is settlement potentially on the cards? Can we push out responding because settlement is on the cards? You need to understand this. Is there litigation? Has there actually been 2 years of running complaint from this person with hundreds and hundreds of legally privileged documents being produced? These are all key things that you understand before you start looking at the actions you're going to take. How are we going to search, blah, 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 blah. And then understand that the action you take in week 1 will potentially impact the action you take in week 4 or month 3. You just need to have that plan about how you're going to respond. How many people are going to review? Are we going to go external to review? Are we going to provide copy documents, or are we just going to provide descriptions or extractions? These are not things to suddenly think about later on in the chain. You have to plan it, all right? Do you need a policy or protocol there? Okay. So just in terms of the plan, really, so I'll try and run through here in 1 minute, Annie, from receipt to delivery. What do we need to do? So first, how are we going to respond initially? Okay, they've just asked for a personnel file, a bit more of a common approach in Germany or Holland or Belgium. Okay, that's easy. Personnel file, yeah, there you go, one, two, three, takes about a week, who cares? However, actually this one is Soren. He's just left Lewis Silken, he's filed the SAR, he wants all the data that I hold on him, and he's asked for all the data. And I know that it's because he wants to bring a claim against me. I am going to respond to that in a different way. That probably might be complex, I don't know. So I better do some high-level initial searches to see what volume of data I'm looking at. Is it 10 documents or is it 10 million data sets that I'm looking at? There's an enormous difference there. Then I need to look at, is an extension of time required? Is it complex? Is it not? What are we going to argue? What are our reasons? I must say right now, we are tending to talk about legal complexity, administrative complexity, but also situational complexity. There are some issues with COVID-19 that make it harder to respond to SARs, and our regulator, the ICO, has said in terms they recognise that people are going to try their best, but they might be delayed in relation to responding to SARs. So next point, are we going to narrow searches? Soren has asked for all his data, but do we want to reduce it down to various time periods, various custodians and so on? And then how are we reviewing the data? Are we doing it externally, internally? Are we going to use an e-discovery platform, or are we going to do it by hand in a file with a black pen? So you've got to think about all these kind of things and going all the way. All of this has to then be set out in your cover letter to the data subject Because again, who's your audience? It's a regulator, and they want to know what you've done. And the reason for setting out that transparency is to protect you as a data controller from any complaints. So very, very quick, but we're going to move now on to the next speed dating session, which is what is the most important thing in your country when responding to a SAR? So we left him till last, and he was on mute. He's not going to be on mute now, but Wouter, what about Belgium?
Yeah, so in Belgium, there are like no specific rules on SARs in the Belgian data protection legislation. There are also no concrete official extensive guidelines of the Belgian DPA. Most people are waiting for more concrete guidelines of the European Data Protection Board, and in the meantime find inspiration in guidelines of the ICO or the CNIL, for example. About 3 years ago, we received a letter from the Belgian DPA in which the exemption for the adverse impact on the rights and freedoms of others was given a quite broad interpretation. The DPA stated, for instance, that an employee did not have the right to gain access or obtain a copy of notes, internal notes in the context of an appraisal of internal emails between managers regarding the employee, etc. But the question still arises whether this position is still maintained by the DPA, and also the case law of the DPA does not give or shine a more or a broader light on this aspect. So we are following more or less the ICO, the CNIL, and waiting for more concrete guidelines in Belgium. It's a bit unexplored territory, so you have some flexibility also from tactics to interpret the GDPR a bit in your own way. So.
Thanks very much. It's very useful. It's very interesting. I know a lot of jurisdictions do look to the ICO, and I will say in that regard, Sean's going to talk about it later, they are updating their guidance for GDPR. And next, Marco, Italy. And just bearing in mind time, let's all be conscious of time. Forgive me.
Thank you. I'll be just two very brief points. First point, Italy does have statutory exceptions for Article 15. They're not that relevant here. Let's just mention you're not allowed to ask who is the whistleblower, but that's also out of courtesy because it's like asking who's the killer at the beginning of a novel. So you're just not allowed to do that. One rule which has proven useful is keep it as short and simple as possible, which is a general rule, but especially in responding to a SAR, and especially if it's complicated, the background job must be accurate, but then the outcome must be as direct and schematic as possible to show transparency and to show well-meaning to the regulator, and why not the subject, even if I do agree with your analysis earlier. Thanks, Alex.
Thanks very much, Marco. And I think Jessica?
Thanks, Alex. Yeah, one brief recommendation, maybe more from the practical side. German courts state a general principle: you cannot hand out what you don't have. So if companies have been diligent in bringing order to their data and implementing a data retention and deletion system, they have less data to worry about. That helps from the practical perspective and from the amount of data.
That's very useful. That is actually a brilliant point, and we do raise that a lot with our clients. The reason why perhaps we are finding it so difficult is because you haven't effected a proper retention policy. And indeed, we have had a few ICO complaints where they've had absolutely no problem. I can see Sean's nodding because he did them with me, but where they have no problem with how we've responded to the SAR, but they have given us a gentle nudge that perhaps we shouldn't be keeping data forever. So it is a key point. And by the way, it impacts every single other right. It's much easier to erase data if you don't have it. It's much easier to keep data accurate if it is evergreen. Ilse, just in Holland, what's the most important thing in Holland?
The most important to do, or actually not to do in Holland, followed from case law, and is that for HR people, please do not provide internal handwritten notes by managers, which are actually solely meant for internal discussions. So for example, if a line manager is preparing a year-end assessment and is making some handwritten notes, or also notes on his computers, these should not be shared with the employee who is asking for it.
And what's the, and is that's guidance from the Dutch DPA, is it, or is that just an interpretation from Dutch data controllers from the GDPR?
No, it follows from case law.
Case law, forgive me. Yeah, interesting.
Case law, yes, yeah.
That is interesting, because we have very many great discussions about that in the UK, specifically say in relation to investigations. When there's an investigation that's happened and someone files a SAR, we have to do this balancing exercise between the right of a third party and the right of a data subject, and it can go either way. But that is quite fascinating that there's a prohibition there in that regard. And I think, Linda, in some regards, there are certain things like that in Ireland as well.
Yeah, actually, so we have an exemption which is around the confidential expression of an opinion. So you can withhold data when you're responding to a subject access request where it was an opinion given in confidence. Now, employers get very excited about that if there are emails between managers talking about employees, that those are opinions and that they don't have to disclose them. But actually, our regulator says it's a very, very high bar, and that they do anticipate that if it's something talking about an employee's performance, it still will be disclosable. So it's a really high bar. So the takeaway would be, don't just apply it blindly. Make sure you take some advice on whether it applies or not.
Thanks very much, Linda. And Sean, just a couple of points on the UK.
Yeah, I think so. The top three are the ICO has a very good subject access code of practice, which, as you say, is going to be updated soon, but still the principles from the 1998 Act still do broadly apply. Looking at proportionality, I think looking at the context of the SAR is very important. So although we've said it's motive blind, let's say an employee is raising a DSAR in the context of performance dismissal, we would look at the key actors and we would be searching their inboxes, not everybody's. We would look at search terms focused on the performance, and we'd search for the date range through which the issues arose. We'd use that context to narrow the searches. And the final point is a lot of clients do get slightly concerned about the third-party data and embarrassing opinions coming up. Alex, you're going to talk about the case of Dr. B versus GMC, which talks about there are ways to protect that third-party data.
Thanks very much, Sean. It sounds like you've got an amazing supervisor. Sorry, just finally the position in Denmark, just for a minute, and then we'll move on to the last formal session.
Yes, just staying with third-party data quickly, I think in Denmark we're contrary to the situation as Wouter explained in Belgium. I think we're more like in Ireland, because in the Danish supplementing legislation, it's actually stated that you can only withhold third-party data if there is a clear and fundamental interest on the part of the third party in not having the data disclosed. So actually they can get access to quite a lot of data, the requester, which contains third-party data, and it's a very high bar. So it seems like it's a bit like in Ireland. Secondly, in relation to emails being requested, the Danish Data Protection Agency has a quite interesting and helpful standpoint on that, because if you see those requests where someone requests all their emails from the entire employment, the Danish Data Protection Agency are saying that all those emails that are purely work-related are actually not really personal data. They more describe a function rather than actual personal data, and therefore you don't have to, as a data controller, disclose it. So that is obviously incredibly helpful in those any and all requests.
Yeah, that is very useful. And in fact, that's something we always grapple with in the UK, and that some data subjects still say, I want everything, even if they're still current employees and have access to their emails. And we have to explain that's not proportionate and so on, but it sounds like very useful guidance from the Danish regulator there. So I'll just very briefly do really a whistle-stop run through some UK case law. Not, obviously it's our area of expertise, but it's just because some of these cases are fascinating, and then we'll touch on some of the guidance and case law in the European jurisdictions to end. First one, Dawson-Damer versus Taylor-Wessing. This is a very famous case, went all the way to the Court of Appeal. Obviously, this is a SAR against Taylor-Wessing, against the law firm, very prestigious law firm in the UK and worldwide, one of the world's largest law firms. So law firm were acting for trustees of a Bahamian, I think, trusts. They received SARs from the beneficiaries. Obviously, the beneficiaries in some dispute with the trustees of the trust, as is very common. The requests were simply refused by Taylor-Wessing on the basis that all data would have been covered by privilege. All data, because of course, their client were the trustees, and everything that Taylor-Wessing were doing under privilege. Now that seemed to me at the time, and I think we all talked about it, quite a reasonable approach to take. but a claim was brought by the beneficiaries in the High Court, and it went all the way to the Court of Appeal. And it is quite complex, the judgments. But the key 2 points are, Taylor Wessing was not entitled to rely on proportionality arguments, i.e., I don't have to look at any of this because it's all privileged, that weren't tested. So it's quite a fascinating look at how the ICO and the courts might look at this. So actually, if they'd tested it, they probably would have found that all their stuff was covered by privilege. There was an issue here, by the way, about Bahamian privilege and England and Wales privilege, but I'll leave that aside. But this is really writ large how to approach a SAR. Always think about proportionality and testing assumptions and reasonability before doing something. Because although Taylor Wessing's approach, to my mind, as a layperson and as a lawyer, was reasonable, of course what we've done for clients is privileged. They needed to test it. So when we act for, you know, professional services firms and so on, we often put in place a sampling system where we might look at 1,000 rather than 20,000, and they're all covered by privilege. Well, that's us testing our assumption. So it's all about proportionality. And again, there are multiple cases saying this, but the SAR regime does not recognise a motive test. Although interestingly, they do hint at abuse of process in a court claim potentially being possible. But that is a fascinating case to read. Sean mentioned B versus the General Medical Council. Now, this is the application of a mixed data exemption, i.e. where data is mixed between the data subject and a third party. You can't separate it. And the GMC was proposing to disclose a report containing an assessment of a doctor's competence when treating a patient. And that doctor challenged the disclosure. They said that will impact my third party data. You cannot do that. I don't want the patient to see my data. And in fact, the GMC did disclose it. And the key point here is that the Court of Appeal said, no, that is absolutely fine, because in a mixed data claim, the requester's motive may be relevant to the balancing exercise, but the court should not second guess the data controller's decision. So although we often have to look at this balancing exercise, is the third party right outweighing the data subject right? Or in this case, is the data subject right outweighing the third party right? As long as we're logical, reasonable and coherent, the court should not second guess a controller's decision, because ultimately these are shades of grey. They aren't black and white decisions. And even what is personal data, even though it's clarified now, there are still shades of grey in what is personal data. And it would be brutally unfair for a court or a regulator, as long as you've been reasonable and proportionate and all your letters have been good, to actually question that. So that was a fascinating case that we utilise all the time. It's a Hadier versus Chain and Deere versus Oxford Union. 2 points really here. 3 points here. So again, collateral purpose does not invalidate a SAR. So a crucial point that's come out of UK case law, and I'm sure will be reflected around Europe as well. Proportionality, again, though, writ large in the case law. So not just the ICO talks about proportionality, but our courts. A requester may be entitled to know what data about them was processed at a meeting they attended, but where they've already received that data, that may go to the exercise of the court's discretion. So that's similar to Soren's point, i.e. it's disproportionate for us to provide stuff that you've already seen or vanilla stuff, but it still means, going back to Taylor Wessing, we have to test that assumption. So it all brings it together to really, we've got to think about reasonability and proportionality. And then searches. This is a wonderful thing that, as you can imagine, Sean and I and Soren quoted a lot. The requirement is for a reasonable and proportionate search, not to leave every stone unturned. And that is a crucial thing, because of course the data subject wants you to remove and look under every stone, but we don't necessarily have to. So moving on to the final speed dating section, we're going to start with Holland. So Ilse, if you could just let us know, is there any case law or any really swanky guidance that we need to know about?
Yeah, there's actually one case, Alex, which was quite recent in 2019. Employment law practice in the Netherlands shows that SARs and requests for copies of personal data are usually met by employers simply providing actual copies of documents. And according to one of the Dutch district courts, this is actually not strictly necessary. So only if certain forms of personal data are difficult to include in an overview, the employee is actually entitled to a copy of the documents containing his personal data, simply because that is the most effective way to comply with the SAR. And from an employment law aspect, you can then think about, for example, the end of year assessment as such document. Well, we could, of course, argue that the discussion by this Dutch court was perhaps a little bit theoretical, because a SAR will often be made precisely for the purpose of obtaining copies of such documents. However, for you as an employer, it's good to know that the right of copy in the Netherlands, based off the ruling of this Dutch court, does not automatically mean that the employee concerned can demand actual copies of all documents in which the personal data are included. He is rather entitled to an overview of the personal data which are kept by the employer. And then another case of the Dutch Data Protection Authority of last week. It's a little bit of the beaten track because it's not employment law related. However, the DPA has imposed on the 6th of July a fine to the Dutch National Credit Registration Office, which we Dutch people know as the BKR in the Netherlands. And this is an office which is quite important if you, as an individual, want to apply for a mortgage. And the Dutch DPA has imposed a fine of 830,000 euros. And the reason therefore was that BKR has imposed specific thresholds before allowing individuals to access their personal data from BKR. Well, in particular, the BKR has asked for a payment of a fee when individuals submitted a SAR. And second, BKR only allowed individuals to access their data at no cost once per year and only per regular post. So specifically, the Dutch DPA decided that BKR has violated the GDPR as the GDPR provides, you already mentioned it, that data controllers should allow individuals to access their personal data free of charge.
Yeah, and that is, I did read that decision. It came out on the NYOB feed the other day, which is Max Schrems's feed, which we probably shouldn't read. But yeah, that is fascinating because that is actually a huge fine from a SAR perspective. We talk with our clients about the risk of SARs and fines, and for a first offence, it's very rare. You know, if you had 20 complaints in a year, it would look like a systemic failure. But this is writ large, clearly in their own protocols, systemic failures to respect the fundamental rights. That is an absolute no-no, and that is a very good point. I mean, Sean, just in the UK, are you able just to give us one quick minute on exciting?
Nothing really further than what you've added. I mean, Dr. B versus GNC is, I think, the most useful case that we rely on for that third-party data exemption. Often, you said that we discuss internal notes, and we'll often have people who have raised grievances who say they want to see all of the notes of the people that they've complained about. Now, that would clearly be an imposition on the rights of those third parties who are having confidential discussions with HR or whoever it may be. So I think that would probably be the most important case that we'd be relying on in those kinds of situations.
Yeah, thanks, Sean. I mean, one thing that's quite interesting is those people who've done investigations and so on that have told people who they're interviewing, by the way, this is totally confidential and only we will see it. It's very much easier than to bat back a request for a SAR there because the weight is very much in favour of the third party. Soren, just in Denmark, very quickly, one top case.
Yes, we actually don't have any case law yet in Denmark because, well, there isn't any, but the Danish DPA, they can't issue administrative fines, but they have issued a notice of intent to fine a data controller for not having complied properly in responding to an access request. So what happens in that case is that the Danish DPA has reported the data controller to the police. The police will carry out a full police investigation, and then they will be prosecuted and taken to court. But I think Denmark and Estonia are the only two countries who can't, whose DPAs can't issue administrative fines. That matter I was talking about was about a controller who deleted some documents after receiving a SAR, so it's obviously quite a serious violation. And I think the intention or the amount of the fine was 700 euros, so it's not a massive amount, but it was a very, very small data controller. But we don't have case law yet, but we obviously have loads of decisions from the Danish DPA.
Well, that's why 700 euros is nothing, but when there's 700 euros times, say, 3,000 SARs, or something, you start getting into interesting things. I will also say in the UK, we do have a criminal regime as well, but it's very, very high-end naughty stuff, i.e., you know you've got this document you need to disclose, and you just burn it. that is when you might go to prison. So we obviously strongly advise our clients not to do that. I think in Ireland, any case, anything exciting from the regulator, any exciting commentary?
So like a lot of our case law would be very much based on the UK case law, but I think what's interesting is our regulator recently issued a report on their activity in the last 2 years since GDPR came in, and 23% of their complaints or information requests have related to subject access requests, which is their single most biggest area of activity. So we only expect that to increase, particularly with post-COVID issues around grievances and redundancies and pay cuts and things like that. But there's still very much work on trying to resolve matters amicably between the data controller and the subject access requester. So that's still the position here.
Yeah, and I read that. I read the Irish DPC report about what had happened from their regulatory perspective over the last year. And what I'd be interested in is how many of those 23% of complaints were then cited in other complaints. You could see someone being investigated for something else, and then they would raise because it's part of their compliance profile. That's what controllers need to understand. 700 quid fine, 700 euro fine in Denmark. Okay, it's nothing, but you're on the regulator's radar. So the next time you have a breach, they'll think, that company doesn't know how to do data. So you've got 3 countries which are going to do: Belgium, Germany, and Italy quite quickly. Walter, what are you thinking in Belgium?
And so in Belgium, the DPA is getting more and more active, also with respect to data subject rights. Only this week, the Belgian DPA also imposed a fine on Google Belgium of 600,000 euros for a violation of the right to be forgotten, for instance. But also there are some decisions, smaller decisions with respect to the right to access. There are some decisions where the DPA ordered a company to comply with an access request, and there's also one fine, a small fine of 10,000 euros imposed to a company for not answering a request in due time. But basically these decisions just confirm the basic principles of the GDPR and the delay of 1 month, etc., and do not really materially change the way how SARs should be dealt with. But we expect more and more cases in Belgium to come.
Thanks very much. And Jessica, in Germany, anything exciting?
Yeah, yes, we have an exciting lawsuit and a hearing before the final employment court, the highest German labor court, coming up about the, actually really about the proportionality, because the second level court decided against car manufacturer Daimler, by the way, that the employer was obligated to hand out copies of all emails and documents, even confidential information, because the employer was alleged to fail to show how third-party rights and confidentiality demands would be impacted. So this is going to be interesting. The court hearing will be on 2nd of September, so stay tuned on that one.
And that will sort of give us some colour in Germany about how far proportionality can go.
Exactly.
Right.
This is going to be guidance, really.
And by the way, all countries really, even post-Brexit, we will probably look at some of those and cite cases like that, because GDPR is GDPR. So any kind of case that is like that would be very welcome. Unless, of course, Jessica, they say you've got to provide everything, in which case I'm going to ignore that decision. But and then Marco, just last but not least, just a couple of minutes on Italy.
Thanks, Alex. The key takeaway from Italian case law, or Garante, which is the DPA decision, is on disciplinary processes and investigations, because you have to be mindful of what you say you have. We have had quite a renowned case where the employee requested evaluation on his disciplinary process, and it was a standard procedure publicized in the company. So the employer was obliged to give all the evaluation leading up to the disciplinary decision. And of course, this gives the claimant important documents. Some help from this side comes from older Garante decision, which relate to the insurance company, where a couple of years ago, there was a number of SARs about doctor evaluation for insurance cases. So people basically brought a claim for the insurance case and then went to the insurance to say, wait a second, what did the doctor say when you asked him or her to evaluate the case. And that's where the Garante, that was pre-GDPR, but put a stop to it and say, you cannot have this because this amounts to a smoking gun, and smoking guns are out of the SARs domain. We'll see if this reasoning sticks to employment cases going forward. Thanks,
Marco. That's very interesting. And that's really what we want to talk about, Annie. I mean, I've said here SARs are coming to a place near you, be prepared. But frankly, from the speed dating, it sounds like lots of jurisdictions are already well on the way to the wonderful UK and Irish model of aggressive SARs and difficult SARs. I don't know, Annie, did you want to say something, or do you want me to do some questions? I've got one question for the panel.
Yes, take some questions. I saw that we already got a couple in the beginning. You might want to answer those, maybe?
I will. Yes, I was following the wrong thing, Annie.
Yes, they're in the chat, actually. Yeah,
okay,
sometimes,
excellent.
yeah, people
can you read them to me? Sorry.
Yeah. So the first one is a bit long, so I'll try to. So UK SAR requests often contain personal data of persons other than the data subject, specifically if emails are requested. With Brexit, from an EU perspective, UK becomes a third country. Could we deny the handout of such emails because it would violate the GDPR, password transfer of personal data to an unsafe country?
That actually is an interesting point. So there, let's say there was a UK SAR, yeah, and it contained data of EU data subjects. Yeah, look, that could be something that you could put in a balancing exercise. You could say that the data subject doesn't necessarily want from the EU their data to go into the hands of a UK data subject. I don't mind that argument. Let's see how that plays out. I think that could certainly be put in the balancing test, and I think that could probably apply to all the balancing tests around Europe as well. One question, Annie, I just wanted to ask the panel, and I'll give it to Soren maybe. What we do see from data subjects a lot is this: SAR against UK data controller, but also I want my data that is held by the US topco and the EU subs, and that then becomes a cross-border SAR. And I just wonder, Soren, what you think is the best way of dealing with that? Do you think there should be multiple SARs in each country, or should one country take the lead, and then broadly we all try to fit in our own regulatory position? On mute. Soren, you're on mute.
Classic, sorry. I would certainly try to organize it centrally, and well, you obviously have to look at who's the data controller in each jurisdiction and all that. But I think actually, I'll go back to a point that's been mentioned earlier. Your narrative to your regulator is so incredibly important. And particularly, I think in those jurisdictions we've heard here today, where the guidance and the decisions coming out of the regulators are not that settled yet. You really need to be able to demonstrate to your regulator that you've taken a sound approach and been reasonable in your response. And because the guidance is not really settled yet, it can really come down to your arguments in why you've not disclosed certain documents and why you've done this and this and that. So I think that's incredibly important that you coordinate that across the board, so you have the right response in every jurisdiction that you have to respond in, if you consider it as multiple requests.
I think that's right, Soren. I think the key is to have a narrative that, look, we've taken respect of the Irish position, the German position, and the Italian position. We've done our best. It's still all proportionality. We can't answer this 15 different times. I think, Annie, there was one last question, which I will just answer and then hand over to you, Annie. Does the response not depend on the DP policy? If it states that you keep records for 8 years and then responding to someone who left 15 years ago would be no need to respond. That is the point that Jessica was making. If you actually have a retention policy where you have deleted data and someone is outside that protocol, then I would still, as per Taylor Wessing in the UK, do a small test. I would still search for Jessica Jacobi and Dr. Jacobi and so on, just to test whether we had any data. But if that came up, as we say in the UK, a lemon, i.e. no data, I would not go further, and then I would show to them our retention policy, and I would broadly say, thanks very much, but this is what we do. Our retention policy is our retention policy. So that's a good point. But it is very rare to have a company that is quite up to date and up to spec with their retention protocols at present. And with that, I will leave and hand over to Annie, and I'll just say thank you very much to everyone who attended. We have a lot of people there who stayed right until that last second. So thank you very much.
Thank you, Alex. Yeah, we're conscious of time, so I'll just need to wrap up. So as I previously mentioned, the presenters will remain available by email, I'm sure of that, for any questions that you might have. And you can find their contact details on the slides that were displayed today, which will be available on our website along with the recording link. I'll make sure of that. And lastly, also from my side, I would like to thank everybody for attending, and thanks also for our great presenters for all of their insights. So with that, this webinar will now be ending.